Professor Maša Galič.
I'm currently an assistant professor at the criminal law department at the Vrije Universiteit. I have a very classical legal background, and I think I can point out that I never wanted to study law, which I found rather boring and tedious, and I wanted to study philosophy. I explored the various issues that have to do with how the police use digital technology, but also how criminals use digital technology. The first implication is always for privacy. Smart city projects, we're claiming we actually are not interested in identifying any individuals. We are just looking at things on a more general, broader level. We're only big brother to the masses. Each time surveillance pops up, people like to resort, and journalists as well, it's a sort of panopticon. The panopticon metaphor assumes a central figure overseeing everything. And that's not necessarily how surveillance takes place today. Yes. The goal of surveillance isn't necessarily discipline. Surveillance is not just about control, it is also about care. You talked about participatory surveillance as self-control. I would probably go further. It is also self-creation.
Yeah.
Actually, my message is we need to find and create safeguards during the official state of the investigation, but especially also before an investigation is even opened.
That's a beautiful way of describing how your expertise developed, actually. I'm very sensitive because I also kind of resonate with what you said. And so this is how I imagined our conversation. So back to you.
Welcome to the Just AI JMCE podcast, where esteemed experts from across the globe address the most pressing issues on AI technologies, their regulation, and the resolution of disputes involving them. When Bentham first conceptualized the Panopticon, a metaphor for an all-seeing disciplinarian, he could not have foreseen the profound impact data would have on the nature of surveillance centuries later. In today's episode, Professor Maša Galič explores how, in the context of smart cities and living labs, datafication has transformed mass surveillance, shifting its purpose from discipline to care, and involving the active, willing participation of those being observed. This shift, however, raises interesting legal questions. In an era of pervasive surveillance and data sharing, should the notion of personal privacy give way to group privacy? In criminal procedure, can AI tools used to collect data in investigations be trusted as reliable instruments for fair and informed court decisions? These are only some of the many issues Professor Galič addresses in today's discussion. So join us for this insightful and thought-provoking conversation as Professor Galič talks about her work and challenges us to rethink surveillance, privacy, and justice in the digital age.
Welcome for yet another episode of the Just AI JMCE podcast. And today it is a pleasure and a privilege to have Professor Maša Galič. Maša, welcome. It's a thrill to have you on the podcast. I have personally been a big fan of your work, and I have followed your work for a while now. So it's really a thrill to be able to talk to you a little bit about it. So the way that we generally proceed is we ask our guests to say a few words about themselves, provide some biographical information, some biographical context, and particularly kind of address the issue of how they became interested in the questions that are now being addressed, in their work, or that they address in their work.
Okay. Well, thank you very much, Ljubčo, for inviting me to this podcast. It's really an honor, yes, to discuss these topics with you, because I know you are an expert on similar issues. So I'm very interested in your opinion on them. I work actually at the Vrije Universiteit in Amsterdam. I'm currently an assistant professor at the criminal law department at the Vrije Universiteit, where I explored the various issues that have to do with how the police use digital technology in investigating crime, but also how criminals use digital technology. I teach cybercrime law, amongst other things. But I started off in the Netherlands doing a master's program in law and technology at Tilburg University, at the Tilburg Institute for Law, Technology and Society. my alma mater, where I did my PhD. And I have a very classical legal background. I studied law in Slovenia at the University of Ljubljana. So I have a bachelor and a master's generally in law from there. So then it was a question of, well, where do I go from here? What exactly would my specialization be? And I think I can point out that I never wanted to study law, which I found rather boring and tedious, which I think people who are not lawyers might understand this sentiment. And I wanted to study philosophy. So I've always been interested in more theoretical questions, theoretical issues, and finding this law and technology master's program, I thought that was a great opportunity to study both something much more theoretical, that questions the underpinnings of law because of these new technologies and how they are used either in outside of the law, but also in the law. And then, of course, looking into the future and not just into the past, right? And one of my favorite courses then were about privacy and also cybercrime. So I stayed at Tilburg and I did a PhD on privacy in public space. And it was a very theoretical PhD as well, not particularly legal, also because the notion or the concept of privacy and the right to respect for private life, as we find it in the European Convention on Human Rights, is a very theoretical type of topic. So from there, I focused more on cybercrime. That doesn't necessarily flow directly from privacy, but at the same time, it also does, because the use of digital technologies, especially by law enforcement, well, the first implication is always for privacy. So I was really fascinated by that, because, of course, it's not just criminals who use it. Also the police, especially in the Netherlands, a very highly developed country in terms of information and communication technologies. So the police use really sophisticated IT, including AI. So that was very interesting to me. And that's how I ended up eventually at the criminal law department here at the VU. Also because as a privacy scholar, I was missing a little bit the more concrete national legal framework to apply these general principles to. Instead of just looking at fundamental rights or the GDPR in terms of data protection law, right, at the EU level, which is also very abstract. I really wanted to dig into the Code of Criminal Procedure, for instance, or the so-called Police Data Act in the Netherlands, which is the implementation of the law enforcement directive. So the data protection legal framework for law enforcement.
Yeah. Wow. That's a beautiful way of kind of describing, how your expertise developed actually. And I really, I am very sensitive because I also kind of resonate with what you said, and with when you mentioned that initially what you were interested in was philosophy, and so philosophy, this interest kind of led you to tackling data privacy, the concept of privacy, and then kind of moving on to procedural law and a criminal procedure rather. And so this is how I imagined our conversation. I wanted us to start with some of the more theoretical work, which I'm again a big fan of, and I really enjoyed reading. And of course, unfortunately, we do not have time to cover all of the aspects because it's extremely rich and extremely thought-provoking. But apropos this mass surveillance or surveillance in public spaces issue. In one of your works, you mentioned the Panopticon metaphor, which is originally Bentham's, and then it was kind of taken over by Foucault. So it seems to me that, the big data phenomenon kind of triggered a shift from surveillance happening in physical spaces and to physical bodies. And I think this is correct me if I'm wrong, but I think this is something that you also kind of mentioned, to surveillance happening in digital spaces and to individuals, data doubles, as I believe you call them. So expanding on this concept of data valence, first of all, how do you think that surveillance, mass surveillance or surveillance in public spaces has changed under the influence of digitalization? And do you think that the objective, the goal of surveillance, which is discipline, as you point out in one of your works, has been affected, has changed due to datafication?
It's a that's a very nice and complex question.
Yeah.
I would slightly rephrase it in the
Uh-huh.
sense that there isn't necessarily a complete shift from physical surveillance to now digital surveillance, because physical surveillance is, of course, still taking place.
Yeah.
We are being surveilled now just in additional spaces, which are nowadays primarily digital spaces.
Yeah.
So everything we do online, and in any case, almost all of our physical actions will also leave some trace or impact digitally, simply because we carry our smartphones with us that track our location, simply because each time we use an application that is also being stored. If I'm looking at my train application, again, where I live and where I work will clearly be visible and to others, and all of these sorts. So physical surveillance and surveillance in public spaces as well is simply still taking place. It's just being done through digital technologies, of course.
Right.
So in fact, physical surveillance has increased with time, because before it was done through, your neighbors or the local police officer patrolling the street. And now it's done not only by cameras, which in some countries and in some cities are really predominant. And it's not only the UK, which I think has the highest percentage or number of cameras per citizen, but also in the Netherlands. So we have also other types of sensors, which is very interesting, right? We have all sorts of sound sensors and sound cameras. So a sound camera is a technology that can pinpoint the location of a particular sound. Then you have all sorts of Wi-Fi tracking technologies. What else? You have so smart cities and living lab projects are also, this used to be a hot topic when I was doing my PhD. So this is now going to be 10 years ago, but and now it's being talked about a bit less, but it's still taking place, of course. And these technologies are still in some occasions, to be found in public spaces. In my PhD, I explored the specific living lab in Eindhoven. There, they also have had adaptive lighting, trying to influence the atmosphere on the street. It was a nightlife street, if that got a little bit out of hand. So we have to realize that there are all of these sorts of digital technologies collecting different types of data that amount to surveillance. So you have the surveillance taking place in all types of spaces, physical and digital, and at some point they might be converging, depending on the actors, depending on the purposes.
Yes. Yes, indeed. And so, based on that, how do you think that this concept of is this concept of panopticon as originally kind of conceptualized? Do you think that it allows us to capture the as you say, the various types of surveillance that are kind of happening simultaneously, or how can is there a need to reconceptualize surveillance? Is the point that I'm kind of trying to make?
I see.
Yeah.
So this concept and this term is highly popular. Also amongst the public, right? Each time surveillance pops up, people like to resort, and journalists as well. Oh, it's a sort of panopticon. I understand where that's coming from, and it's a great metaphor, and it's very well known. But this is actually a concept that has been highly criticized in surveillance studies, precisely because it doesn't really apply so well anymore to the different types of surveillance taking place. The panopticon, the way, even though originally it applied to this specific octangular building, a prison with a central guard, but you can apply this type of surveillance to other places and institutions, of course. But it doesn't really render well or apply well to the new types of surveillance taking place. The panopticon metaphor assumes a central figure overseeing everything. And that's not necessarily how surveillance takes place today. So that's why we have now various types of conceptualizations of surveillance increasingly. So one is, you talk about data doubles. Gilles Deleuze talked about individuals. Instead of individuals, we're all divided now into little parts, depending on the digital traces that we leave behind. And also, you have, for instance, a type of surveillance called participatory surveillance. And this brings me back, you mentioned before, the goal of surveillance, if thinking about the panopticon, was to discipline people because you know you are being watched. You discipline yourself already. You don't need someone else to discipline you because you do it by yourself. But actually, the goal of surveillance isn't necessarily discipline. The usual distinction that is made, and that is oftentimes forgotten by surveillance scholars, including me, is surveillance is not just about control. It is also about care, right? So nowadays, surveillance is also being used a lot in old people's homes, for instance. In order to prevent, well, either also abuse, which is partially control, but also simply to take care of your elderly parents or other family members or someone else in any case. So it is a lot about care. And some people and types of surveillance are also participatory and can be enjoyable. Just think about all the people wearing smartwatches. Right? That's a type of surveillance. You're keeping track of yourself, your location, your heart rate, your blood pressure. I don't know. I do not have a smartwatch, but that is people willingly participate in this, probably also knowing that this data is shared with the producer of the smartwatch and potentially further. But they either don't mind this perhaps and just enjoy the benefits of this surveillance, which are also tangible, at least for some people.
Yeah, that's it's really a brilliant answer, I think, because I'm again sensitive to your answer because one of the things that I'm thinking about right now is how new technologies participate in the construction of individuality and subjectivity. But anyway, we will have other occasions to talk more about that. But you mentioned something that I was very curious about, and that is precisely this concept of participatory surveillance. And so when you say participatory surveillance, conceptually mean when the subject is willingly sharing their data. or participating in the self-control or the control of the self. So if you could clarify that for us. And also, now if we're kind of tackling the more legal dimensions or legal aspects of the research, how does this participatory surveillance upset, or does it at all upset, any canonical views or requirements on privacy and data protection? So what are your thoughts on those issues?
Very good question. Well, participatory surveillance, I think originally this notion, and I think it was Anders Albrechtslund who pioneered this notion. It really had to do with enjoying surveillance and self-surveillance, right? So I think most of us don't know these examples, and certainly not my students who are in their early 20s. But in the 1990s, you had a couple of individuals, with the emergence of the internet, and who were basically recording their lives 24/7. Obviously not fully 24/7, but as long as they were either in their room, in front of their computer, everything was recorded. And they did this willingly and wittingly and massively enjoyed it, at least for a certain period of time. And we still see this today, right? Nothing has changed very much. If you think about the participation in social media, posting all sorts of videos, all sorts of banal things from your daily life on Instagram and TikTok and whatever apps that are particularly popular right now. So yes, it is in a way, you talked about participatory surveillance as self-control. I would probably go further. It is also self-creation, right? The creation of your online persona.
Yes.
Which I'm sure can also be a very, or perhaps a healing, healthy aspect of someone's life, to be able to present themselves the way they want to online. It might also have some negative impacts, but it can also have positive impacts in this sense. So yes, self-control of self-creation.
Yes, and as I listen to you, I think about Simondon, for instance, who was read by philosophers like Deleuze and Derrida, and he kind of spoke about this process of individuation and including new technologies in a process that he called transduction, which is establishing coherence between forces that are not necessarily in sync, or I mean, I'm simplifying and caricaturing, but this concept of individuation has been taken over by the philosophers, the French, some of the French philosophers in the 90s, to already kind of hint at the role that technologies might play in people's subjectivity or individuation. And of course, then there was Latour, who came up with this actant concept. Anyway, again, that's a conversation, I think, for a coffee at some point, if you don't mind.
I would love to.
Yes, I'd be delighted to. I'd be delighted to continue this conversation further. But now moving, you also mentioned some of your studies that addressed smart cities projects, like the project, I believe it's called City Pulse in Eindhoven, and I don't think that this is the only kind of smart city technology that you studied. I think you studied several. But City Pulse, if memory serves, it was a system that was able to detect kind of weird walking patterns of individuals in public spaces, and also, if memory serves, so there was, of course, a case of mass surveillance, obviously, but people's faces were blurred. Am I correct in thinking this?
Yes.
And so because of this, in one of your works, you raised this very interesting question of are the data subjects identifiable within the meaning of the GDPR, right? Article 4, since you cannot really kind of see their faces. So first of all, what do you think about this concept of identifiability within the context of mass surveillance, but also, so that's one aspect. And the other aspect is something that you mentioned in the work that I'm referencing, which is the concept of group privacy.
Mhm.
And so could you elaborate a little bit on that as well, if you don't mind?
Okay. Yes, so indeed, City Pulse was one of the projects taking place within this living lab within the smart city of Eindhoven.
Yeah.
And the living lab, just to quickly clarify what this is, because I think people are familiar with the term smart city, but the living lab is also an interesting notion, very much connected to smart cities, but also a little bit distinct. So new technologies developed for the purpose of a smart city, right?
Yeah.
Trying to achieve, I don't know, whatever, either increased, improved infrastructure or increased security and safety in the city, things like that. And the living lab tests different types of digital technologies in the environment itself. That's why it's called a lab, a laboratory.
Yeah.
Of course, it's not a real experiment because, well, it doesn't really fulfill the requirements of proper experimentation. There is no test group. It is just, there in real life digital technology that is still being developed. It is already being tested to see if it works.
Yeah.
Now, precisely because there is no test control group, then it's difficult to measure what the effects of this technology actually are and whether the goals are achieved. But that's kind of the idea.
Okay.
And so in this project, in the Stratumseind Living Lab, Stratumseind is the nightlife street in Eindhoven in the center, where these technologies have been deployed. And some of these technologies were within this project of City Pulse, which had the goal of improving safety in this nightlife street. As you can imagine, you have a nightlife street. People drink too much. People are sometimes high. Bad things can happen.
Yeah.
And in any case, right, sometimes there are, and amongst other projects taking place, there was also the de-escalate project that I already mentioned with this adaptive lighting. So before even a negative situation or a problematic, unsafe situation would emerge, the idea was to already de-escalate the bad atmosphere on the street.
Yeah.
So prevent anything bad from happening in the first place. And that the idea was to do this through light. So in one of the papers that I co-authored with Raphael Gellert, we look into how do these types of projects, smart city or living lab projects, actually, how can they apply to data protection law? Because talking to the actors in this smart city project, I realized that most of what they're doing, most of the data that they are collecting, according to them, is considered non-personal.
Okay.
Now, of course, they are not data protection experts, so they couldn't explain to me very well why they do not consider it personal. But the idea was, and I have a beautiful quote in one of those papers, it goes something like this: if you want to build houses, there are books and books of laws in the Netherlands. If you want to do something with data, nothing applies. Of course, when we deal with personal data, data protection law applies. But then the question is, well, what is considered personal data, right? The first step of application of this law, it's a very complex question, actually. And it has to do a lot with identifiability. And I've seen throughout my PhD research that increasingly, or perhaps not increasingly, but I've seen it more and more, not just in Europe, but also in the US and Canada, that smart city projects were claiming we actually are not interested in identifying any individuals. We are just looking at things on a more general, broader level. So in Stratum Sein, that was atmosphere. That kept on popping up, right? We want to calm down the atmosphere, increase the safety through that as well. So the point was really not to identify or even single out any individuals. If we can calm the atmosphere and prevent any fights from taking place, then no one needs to be identified, no one needs to be arrested, the police don't need to come to the street, and everything is perfect. So they even quote this nice saying, we're only big brother to the masses.
Yes,
which is a wonderful saying, right? And again, the big brother metaphor sort of panopticon-ish applies.
Sure.
Big brother to the masses, which of course is problematic as well, but all right. So in this paper, I look into this requirement of identifiability according to data protection law and how it might apply to the types of data that have been gathered in these smart city projects, which are primarily what we called with my co-author environmental data. Because they look at what is the weather. Why? Because the weather also influences our mood. The crowding levels, because the higher the crowding levels, the more also people might be irritated. Again, it influences our mood and the atmosphere. Then sounds were captured, right? Was there a scream somewhere? The amounts of also beer sold in a particular evening, or trash collected the next day. So all of these types of data, sometimes at an aggregate level and very much on this environmental level, were collected to assess the levels of escalated atmosphere, how safe or not safe it was. And this brings out problems for this requirement of identifiability. Or singling out individuals, because you collect what in itself, apart from other types of data, are technically non-personal data. But taken together, they might be able, of course, to identify individuals. That takes place especially when databases are combined, which is always possible. But it should also always be looked at or examined in a concrete example. So here we have in smart cities, this is always a public-private partnership, which means you have the municipality, various digital technologies, IT companies, the police, and other actors taking place. All of these different actors, of course, have their own databases. Now, what kind of sharing of data and what kinds of analyses here take place, that is not open knowledge. But in any case, in our paper, we show, unless we can really prove or show that these databases are indeed put together very combined, so that these environmental or aggregate data are combined with new data points from these other databases, actually the requirement of identifiability is not fulfilled. And the purpose itself is also not to identify, because if we can prevent any aggression from taking place, any fights from taking place, then we don't want to identify anyone. So we just basically show how these new applications of digital technologies that do not identify us, do not fall under the scope of data protection law, but they still affect us and affect our behavior.
Right. Yeah, for sure. And I get the argument where new technologies or surveillance done through new technologies might be there to prevent, let's say a crime or something that from occurring. But and this actually what you just said kind of allows me to transition into the criminal procedure questions that I have. What do we do when crime does happen? And also like in my research, I have studied some North American law where they did use certain technologies, to perform biometric identification to then identify an individual that was a perpetrator of a crime in one particular case that I have in mind. Which brings me to this issue of to criminal law and criminal procedure, right? Because also something that I noticed in your work is that you mentioned, and rightly so, that data is becoming more and more considered as evidence or viewed as evidence. So, which is obviously an issue that I address in my own research, and I usually am very much intrigued by this concept of accuracy, right? When data is presented as evidence before a court, well, how would the court know if that evidence is accurate, And so do you think, what are your views on the fact that, datafication, that discovery procedures in civil law, but also in criminal law, discovery meaning procedures meant to find and uncover evidence, have been datafied, so to speak. And how does that affect you as a criminal lawyer, or from a criminal law perspective? How does that affect the concept of accuracy of that evidence? Have you seen any cases where the issue of accuracy of data being presented as evidence was addressed? I know that in some of your work you mentioned, and I found this very interesting, that the Dutch courts do not seem to consider that AI output can be qualified as expert evidence. And so, which, it was a big debate in the United States, for example, whether AI output can fit the expertise criteria, right, in order to be presented as evidence before court. So my point is, how do we integrate this notion of data within, traditional conceptions of evidence, and in particular, accurate evidence? So evidence that can then lead to an informed, ruling or decision in a criminal trial. What do you think? What are your thoughts on this? I know.
No, this is the biggest question of them all. I think I should probably slightly clarify, because what you are referring to, if I understand this correctly, about AI output not being able to, or not being classified as expert evidence, I think in this case it applied to Hansken. And Hansken is a tool. It's actually a platform, so different types of tools, software, for searching for evidence within large data sets, and then also analyzing these data sets in various ways. And what is this tool has been used in a lot of criminal cases in the Netherlands, relating to the cryptophone cases. Mm-hmm. So think about the EncroChat case, or Sky ECC, and all of these other cases where a cryptophone provider, so providing these special types of smartphones that were encrypted with special software that are in great use with criminals, but also perhaps, or sometimes journalists, businessmen, protecting trade secrets and whatnot. So all of these phones were hacked, or the phones of many, if not all of the users were hacked. So this produced terabytes of evidence that needed to be analyzed. Obviously, special type of very sophisticated software is needed to analyze this. And here in the Netherlands, this software called Hansken developed by the Netherlands Forensic Institute is used for this purpose. In some of these cryptophone cases, it was primarily textual data, so messages. And Hansken was then literally called a zoekmachine, so a search engine. Terminology matters, framing matters.
Sure.
So in this case, Hansken was not framed as any sort of sophisticated AI technology, but as a mere search engine. Of course, search engines are huge AI, right?
Yeah.
They are incredibly complex. There's nothing evident about how they function.
Right.
It's not objective. It's not okay.
Yeah.
But where this is coming from, it's actually a little bit more complex because Hansken seems to be seen as a so-called technical tool, help tool, that is in a lower decree in the law, in Dutch law, signified as a mere technical tool and not as sort of complex expert for which expertise and experts and their expertise are not needed. Because it is sufficiently standardized, can be tested, right? So it is assumed that it functions correctly. So we don't need experts in the courtroom to explain what Hansken did and to show and ensure that the results from Hansken were indeed accurate and trustworthy.
Right.
So this is a bit of course, an arbitrary decision. Which tools are placed in this decree as sufficiently standardized? The other things that are listed there, is it has to do with DNA evidence and things like that. So these also still today sometimes problematic methods. But when it comes to other types of AI that would not be found in this decree, and when an expert might use them or an expert might be needed to use them, then AI output would indeed be able to count as expertise and expert evidence, so that the other party would have the right to counter expertise.
Yes, of course.
So it just shows that it's actually a problematic and arbitrary distinction. Which tools do we classify as complex, sophisticated AI, and which tools we classify as mere technical help tools, technical tools, aids, and what is the level of sophistication that is required?
Yeah. But in the case of Hansken, so what is the trend in the Dutch courts? So it's a tool that might be used by experts, but itself cannot produce expertise. And so what happens? And you said something very interesting just now. You said that it is assumed to be correct.
Yes.
So, but what if it's not? Do the parties in a trial have a procedural right to contest the accuracy, the assumed accuracy of that output, or the reliance of the courts on the outputs? So, do you see any trends in terms of how Hansken's, output from a system like Hansken, but also similar systems? And I think you also kind of address a little bit recidivism predicting systems, which, at some point we have all done, I think, since Loomis. But do you see any trends in terms of how Dutch courts approach this issue of accuracy of such output? Like, how do we know it's accurate? And are there any procedural rights that can actually allow litigants to maybe encourage a court to check the accuracy or to reinforce the assurance that indeed the output is accurate?
Yes. Well, I think here we again need to make a bit of a distinction between Hansken and maybe other tools, why Hansken is so special. Hansken is special partially, I think, because it is developed by real experts, digital forensics experts at the Netherlands Forensic Institute. So these are experts, right? And they are not themselves police. They are a special institution. And Hansken was also developed with all of these key values and requirements in mind, including transparency and privacy. And actually, in the first cases, cryptophone cases, that was the NetCom cases in 2018. I think one of the first judgments is from 2018. Courts did have an expert, someone from the Netherlands Forensic Institute, come to court and explain how Hansken functions, what it does, and what the result is. So actually that did take place, and the defense, the lawyers, could ask further questions to this expert, at least at that point. After that, it was considered that Hansken was indeed a sufficiently trustworthy tool, so that it didn't, this question of reliability of evidence and accuracy didn't need to be put into question each and every time. Partially, what I've seen in these cases, these cryptophone cases, I have seen Dutch criminal judges put great trust in the system. Partially, this is because, well, they are lawyers, just like us, or just like me. And, well, we don't understand very well how technology functions. And it might seem pretty clear and objective to us, which is not always the case, obviously. At the same time, these cases, these are cryptophone cases, they related to very, these are, serious crimes. These are criminal, drug-related criminal organizations, and some serious, they were serious suspects at the times, now convicted. So these are not small cases, and I think that also influences, in practice, a person's, in this case, a judge's perception. Well, but we can read based on Hansken, how these messages, and they are talking about murders being committed. So what exactly Hansken did might be less important, because we see that we are dealing with a hard criminal. But like, again, I said, this was developed by proper experts with these requirements of transparency and reliability and privacy in mind. And Hansken, at the same time, at least for certain functions, is not the most sophisticated AI. So I don't think Hansken would fall under the definition of AI as it is found in the AI Act, because it wouldn't be sophisticated enough. It's not automated and complex enough. Of course, I think this is one of the problems. Even if it's not the most sophisticated, complex AI, that doesn't mean that issues do not occur when such a technology actually creates instances of decision making.
Of course.
So this is problematic. But in some other cases, there have been a few cases of when facial recognition was used. And there, if the result of a facial recognition technology was not confirmed by another extra piece of evidence that was not technology produced, then it cannot, according to Dutch law, it cannot lead to a conviction. So we see a different, being a bit more careful when it comes to other types of technologies that are not in-house developed, right, by experts from the NFE, for instance, and that have not yet been properly tested. And this is just a specific Dutch criminal procedural rule.
So the standard of proof is still kind of maintained quite high. But I find it very interesting. I have to admit, I am relatively ignorant of Dutch procedural law, and particularly criminal law, criminal procedure. But I find this distinction between systems that can qualify as AI and systems that cannot, and depending on how we approach them and how we qualify them, that will then determine how we will view their output. I found that very, very interesting because again, it's debatable, as you say. But anyway, again, that's not we will not necessarily go there today. That would be a topic for our in-person conversation at some point in the future. And so we're kind of approaching the end of this episode, which I'm just I find very, very enjoyable, and I became more aware of the points of intersection between your expertise and what we're doing in Liège. So finally, based on everything that we talked about, what would be the main takeaway, let's say, if a providential regulator or a providential or I don't want to say providential judge, but a rigorous court, if they listened to this episode, what would be, or even laypersons, what would be the message? What would be the takeaway? How do you see law evolving? How do you see scholarship evolving? What should experts, but also laypersons, be mindful of moving forward?
Concluding question. And I just want to clarify, I think that Dutch judges, and in general, judges in Europe, or let's say, I think that Dutch judges are doing a good job, a very good job. I didn't mean to criticize their work.
No, of course. Yeah.
Actually, my message is that when digital technology is used in criminal procedure, the focus on the trial and the safeguards that apply in the trial that are very well developed, even though they can always be improved, especially when we have large data sets, right? When evidence collection really relates to processing of data points, processing of data in large databases. Here we see this development also seen in Dutch practice, and also at the level of the European Court of Human Rights, where the defense are getting a right to access to various types of these collections of data, to also participate in determining what counts as evidence.
Yes.
I think this is very important. In Dutch practice, this is a wonderful development. Also, the defense is getting access to Hansken itself, because how can you collect or participate in the collection of potential evidence or defining potential evidence in such huge databases without a proper tool? And then they are the defense now in the Netherlands also has access to Hansken. So this is an amazing development. But what I would actually emphasize is we need to forget or move on a little bit from this focus on the trial, where only certain types of mistakes made, or let's say mistakes that might have been made during the whole criminal process, the chain of the criminal process, might be remedied. We need to find and create safeguards within these previous stages of the criminal process. One is, of course, during the official state of the investigation, but especially also in this preliminary stage before an investigation is even opened.
Yeah.
Because a lot of digital technology, including facial recognition, but also simply a lot of data collection and data analysis is taking place. And now the results of the deployment of these digital technologies, it doesn't directly lead to the production of evidence, but it just leads to the production of what are called, what we would call indications, that when picked up, put together, later on lead to evidence. But those are moments of decision making, right? The decisions are made to zoom in into this direction, into these potential suspects, and so on. So we need to have safeguards in place when during these earlier phases that remain largely unregulated, simply because this never used to be such a huge problem.
Of course, yes, indeed. I agree with you. Access to constitution of pretrial knowledge of the facts is indeed paramount, and especially if at that stage you use new technologies. As you say, and I completely agree with you, there are just additional safeguards that we need to have, procedural safeguards from a fair trial perspective, but also epistemic guarantees, right? That the knowledge that you collect about whatever it is actually reliable knowledge, or a reliable and trustworthy indication. Okay. So, Maša, this concludes our conversation, which I enjoyed very much. I hope you enjoyed it too.
I did. Thank you very much.
Yes, thank
for
you.
For the really pointy, difficult questions.
Well, your answers were brilliant, and I so enjoyed listening to you. And I have a million other questions that I would like to ask you, but I will make sure to create future occasions for those. So thank you again, and we will of course continue following your work, and there will surely be other occasions within the Center of Excellence where we will be able to interact with you.
Thank you very much, Ljubčo, for the invitation and the wonderful interview.
Thank you for watching an episode of the Just AI Jean Monnet podcast, brought to you by the team of the Just AI Jean Monnet Center of Excellence and supported by the European Commission through the Erasmus Plus program. Keep an eye out for upcoming podcast episodes where experts in the field of AI will delve into the significant risks posed by these technologies and propose potential solutions. Stay tuned for many exciting and insightful discussions to come.